firm. Just a little bit about me. I am a Hollywood native. I went to St. Thomas Aquinas at high school in Fort Lauderdale, University of Central Florida in Orlando. Made my way back to Fort Lauderdale for law school at Nova Southeastern. And then right out of law school, immediately began practicing as an attorney advisor for a title company, as well as their in-house law firm, where I explored and got dived right into the practice of community association law, real estate, estate planning, probate. It was a very transactional firm in nature. So a lot of these things started getting thrown at me, and I started to realize how, and it's kind of the topic of our presentation today, when two worlds collide. Many worlds collide sometimes in the legal profession, and that was the business model for my law firm. So that's why I started the legal planning firm. Legal planning isn't actually really a concept. I mean, you hear estate planning, you hear real estate, you hear business transactions. But for me, what legal planning is it kind of brings all of those worlds together. When I'm practicing in probate, I wasn't sure how would I be able to even handle this probate if I didn't have an extensive knowledge of real estate and title. I'm handling a real estate matter. How would I understand this real estate matter if I, don't have a background in business? When you're, faced with helping with negotiations and understanding the business decisions that need to be made. So all of these things really come together for me, and that's the concept of my firm, the legal planning firm, and that gives me the great opportunity to sit here before you all today to just explore the area of when we see a real estate transaction and a probate matter come together, and why it's important to have a really good understanding of both. I know that you guys are the real estate experts in the room here, and I'm serving as, your probate extraordinaire. So I want us to be able to come together, learn from each other, and I think, bring to light the concepts of probate that are going to be helpful and useful to you when you're speaking with clients. I want you to be able to walk away from this presentation today to be able to really walk the walk when it comes to probate, and really just understand what your role is to be able to facilitate a real estate transaction that comes your way that deals with a probate. I'm also open to meet with anybody one-on-one. I know that this always, when I start talking about probate, it really brings to light the concept of estate planning. So that's certainly something that I do. And if you, on a personal level, want to speak with me, I'm happy to go over that with everyone. And it's also a great concept for you to understand, because it is a little value added that you can add for your clients when they're buying or selling, even if it isn't a probate matter. They now own an asset. They're welcome to the club. You now own a piece of real estate, and when you own real estate, you need to, make sure you're dealing with asset protection, estate planning. So that's always something that you can use as a way to just reconnect with clients and letting them know, hey, have you thought about estate planning for your property? And it just can get the conversation rolling with you guys in your past and present clients. Gives them some value added. They'll really appreciate it too, because it really does bring a lot of peace of mind when you're dealing with estate planning. But our topic today is probate. So first and foremost, what is probate? Probate is the administration of assets owned by an individual at the time of their passing. So what does that mean? That means if you own anything when you pass away, those assets need to go through the court procedure, the probate court procedure, in order to have those assets formally distributed to the beneficiaries of the estate. Now, when we're identifying probate assets, those would be assets that don't have beneficiaries named. There's a common misconception that if you have a will, that is equivalent to adding a beneficiary to an asset. That is not the case. A will is actually a legal document that is meant to be presented in the probate court. So if you have a life insurance policy, for example, and you name a beneficiary on that account, and God forbid something happens to you, that asset does not fall through the probate court because you technically don't own that after you pass away. You have it set up where it immediately passes to your beneficiaries. A will, while you're naming whom you would like to receive your assets when you pass away, you are assuming the fact that you own those assets after you pass away. So let's put it right onto a piece of real property. You own real property, God forbid something happens to you, you have a will. The will specifically states, my house goes to my children. Let's just use children as an example here. That's great, but we don't stop there. You're not going to be able to hand that will over to the title company to clear title on that property. You're not going to be able to say, hey, title company, here's the will. See, it shows that these are the 3 owners of the property. They're not going to accept that. They're going to require is a probate every single time. So if an individual owns a property, when they pass away, a title company is going to want from you a couple of things. They're going to want letters of, they're going to want a showing that the probate has either distributed, this particular person has gone through the probate process and they've actually distributed the assets to these beneficiaries. So in that case, your property doesn't require a probate, right? It went through probate and they own it. I'm going to bring us back to, it's just the concept of we haven't gone through a probate yet. Okay, so this person has passed away and they own property at the time of passing. Whether they have a will or don't have a will is irrelevant. That's a takeaway from here. Whether you have a will.
Can I ask a question?
Is irrelevant to that. Okay.
Can I ask a question?
I think, yeah, if you want to go ahead, and then what we're going to do is we're going to do a Q&A at the end, but go ahead.
Okay, I just want to, if we have a living trust, giving the properties to our children, so the probate doesn't come in, right? Yeah.
Correct. So that would be a probate avoidance strategy, which is something that I would, when I was kind of giving the example of a life insurance policy and you name a beneficiary on it.
Yes.
So if your property is owned by the trust, so it's the deed, when you look at the deed. So what you guys want to do here is you're going to look at the deed, right? I'm sure a lot of you do this. And if you ever get a listing or you're about to go to a listing appointment, you can always reach out to me and say, hey, can you pull the deed for me? But we all know we can pop onto the property appraiser website most of the time and pull the deed up and see who's entitled there. Now, if you look at that and you see who's entitled and it's a trust that's entitled, then we're probably good to go. If you look at that and the person you see there is the person that's passed away, right? And then we don't have a probate that's transpired yet, that's happened, then the person that has passed away is entitled. So that means that the title company is going to require a probate in order to clear title for the transaction.
See, okay.
Now, there are a couple of ways to do it when we're dealing with a probate. So there's 2 different types of administration. We have summary administration and formal administration. The administration that we decide to go with is going to depend heavily on how long the decedent, the person that's passed away, has been passed away. So if they've been passed away for more than 2 years, then the summary administration route would be an option for us, so long as the assets outside of their homestead property do not exceed $75,000. Now, the great thing about a summary administration is it's very quick and easy in that you're going to petition the court for a summary administration, and in that same breath, they're going to give you an order for summary administration, which by virtue of that order transfers the property from the estate into the names of the beneficiaries. So now we no longer have a person that's passed away as the owner of the property. The beneficiaries, our living beneficiaries, are the owners of the property. Those become your key players. Those become the people that go on the top of the contract. Those become the people that are going to sign everything in terms of the deed, the closing statement, things of that nature, as themselves individually. They're the owners. Once you get that order of summary administration, they're good to go. Now, that's not always an option here for us, because if somebody's just passed away and it hasn't been 2 years, then in order for me to get that order for summary administration, I need to wait out a 3-month creditor period. So we need to file the summary administration, petition for it, and then in that same breath, publish to creditors for a 3-month period. We don't want to have to wait 3 months though in order to sell our property. I mean, that's ridiculous. That totally defeats the purpose of what we're trying to do here, and that's get these properties sold as soon as we get them listed, right? So where we would want to go with that is what's called a formal administration. In a formal administration, the main distinction between the two is that we get a personal representative appointed, somebody that can sign and act on behalf of the estate. That's the key here. That's what's going to create the ability to sell a property while it's still owned by somebody that's passed away. We ask the court to appoint that person through letters of administration. So that's a key document. Your title company is always going to ask you, I need letters of administration. What does that document do? That tells the title company that we have a probate proceeding underway. And this is the key person that has been authorized by the court to act on behalf of the estate. Now, another name for personal representative in other states, they call it executor. So that might be another word, and that's a fine word to use, executor of the estate. The proper term though in Florida, and what we call it in terms of how it's referenced in Florida statute, is personal representative. So our goal when we're going to go ahead and if we're in a situation where the person hasn't been passed away for more than 2 years, we're always going to go with formal administration because we want the ability to sell the property while the probate is still pending. So what do your clients need to know when it comes to a formal administration? And what do you guys need to know in terms of what we're going to be looking for? Again, we said we're going to look for letters of administration that are going to be issued upon our petition for opening a formal administration. And at the same time, we're going to also petition the court for an order authorizing sale. Now, just because the court says through the letters of administration that your personal representative has authority to sign on behalf of the estate, they don't necessarily have the authority to sell assets of the estate without court order. And that comes down to title requirements, clear title, okay? Because again, any action by an executor or a personal representative of the estate can be questioned, and it's up for grabs by any of the beneficiaries or creditors. So everything needs to be done formally and approved by the judge so that the title company will be able to issue title insurance, because that's the goal here. The whole point of the probate is to set this asset up in such a way that it is clear of any potential probate issues, okay? Any beneficiary issues that may come. So what is a petition for order authorizing sale? A petition for order authorizing sale is just us asking the judge, do we have permission to sell this property to this buyer for this amount? And what we need to provide the judge with our petition is a copy of the contract along with some realtor comparables. That's something that I can help everybody out with. It's super simple. You guys pretty much already have that work done when you're doing comps to try to grab the listing in the first place. We kind of look at, the I'd say 3 properties that are in the vicinity. And even if those properties are selling for higher than what you're selling for, you're just going to point that out in your actual letter saying, oh, well, the reason why ours is, 10,000 under market value is because, the kitchen is completely not in working order or whatever the case may be. We'll go ahead and bring that to light. The main thing is just to give the judge a little bit of an understanding of the nature of the transaction. What they're looking for is to know that this is truly an arm's length transaction and that there isn't any sort of funny business when it comes to us maximizing on the value of the estate. And I can tell you, the judges really aren't strict on this at all. They're not, trust me, your beneficiaries are going to be stricter. If your beneficiaries are going to agree to that price, the person that you're looking for, the judge is going to be okay with it. It's all about getting all of your beneficiaries on board. So that's the main goal here, what we're trying to do and what we're trying to strive for. And what's actually driving the entire deal is all about us getting this probate filed, getting our letters issued, and getting that order authorizing sale. Now, in addition to that order authorizing sale, we're also going to petition the court to designate an estate depository, because this is an important thing for clients to understand. And when I say clients, I'm assuming your clients are the beneficiaries of the estate, okay? Because those are going to be the actual living people you're working with. You're not working with the person that's passed away. Nor am I, right? My clients, when I say my client, I'm talking about my PR, my personal representative. That's going to be our client, right? So when we're talking about our personal representative and how we're going to kind of discuss and create expectations, we always want to make sure that we're creating reasonable expectations for our clients and understanding, number one, when am I going to get my money? How am I going to get paid? Because when you're selling a property through probate and it's still pending the probate, well, we can get that deal done, we can get it closed, we get you guys paid through your commission through the closing statement, we get all the expenses paid from the seller proceeds. When we have those seller proceeds, where are they going? We don't have authority at that point in the game to just write checks out to all the beneficiaries. A title company isn't going to do that, because while we have signing authority by the personal representative, they're signing on behalf of the estate. And I'm sure you guys already know this, but what do title companies say to you when you're giving them wire instructions for seller proceeds? The name on the account must match the name of the seller, right? So in this case, the name of the seller is the estate of so-and-so. So I go ahead and I petition the court at the same time of opening the estate for an order designating depository. So this is just a bank account. It gives me the authority to open up a bank account in the name of the estate. And this account is a restricted account. So what that means is we're not able to draw from that account without a court order. When do I get that court order? After the 3-month creditor period has passed. So let's give you guys a fresh little timeline here. A client approaches you. They have a property. It's the person that wants to become the personal representative of the estate. They contact a probate attorney and they say, we need an estate filed. That estate gets filed. We petition the court for formal administration. We get letters of administration issued. We get the order authorizing sale, perhaps, if we're ready to go on a contract at the time, and we get the depository designated. At that same time, we go ahead and publish to creditors. Now we've published to creditors. We wait that 3-month period out. That money sits. Now we sell the property. In the meantime, within 30 days of you contacting your attorney to go ahead and file this probate, we get the property sold because we have a 30-day closing date, right? That money goes into the estate depository and it's going to sit in that account for the next 60 to 90 days, depending on when that creditor period gets filed. My rule of thumb is I file that creditor period within a week of getting letters of administration. I can't file the creditor period until the letters have been issued. That's a requirement, okay? So once the letters have been issued, within a week, we're gonna be publishing. So it's going to be 90 days from when we publish that they are going to essentially be able to have access to those funds. Now, by access to those funds, that means we have authority to go ahead and petition the court to distribute those funds to our beneficiaries. And that would be kind of how the timeline works and the understanding that you'll want your clients to have. The money's safe. It's in a restricted account. It's being held there. It's not in escrow with the title company anymore. The buyer's completely out of the situation. nobody is involved in the actual closing itself has any access to these funds anymore. Again, they're writing the check out to the estate of so and so. We're putting it into the estate depository. So what are we kind of doing here? We're swapping real property for money. So now the estate doesn't own real property anymore. We sold it through the estate. Now the estate now has money from the sale. So that cash sits in that estate depository until the time comes that we're authorized by the court to distribute that. So that's a really important concept for clients to understand. It's not something that I would necessarily recommend for you guys to really jump into. I think that is more of something that you're going to want to allow the probate attorney to kind of discuss with them when it comes to the money situation and how those things get distributed. But it is important for you to know if, for example, your beneficiary is banking on this cash, right, from the sale, and they think that they're going to get that cash to go buy something, right, within the next, 30 days of sale, and we know that we have a 90-day creditor period. So if you get a question about that, or you sense the situation of that they think that they're going to get this money on the date of closing right into their bank account, you're going to want to just bring to light, listen, I'm not sure if you're aware, but there's, as you know, there's a creditor period, which creates a delay in the distribution of your funds. It's going to have to be held in your restricted estate depository account of the estate before it can be distributed. And you should discuss that with your probate attorney as to what the timelines and reasonable expectations are for distribution of those actual funds. Now, in some cases, you come to me, right? And maybe it's one of those properties a little harder to sell, right? So you come to me right away and I file the letters of administration. I start running the creditor period. You don't even have a contract yet. You're not even in contract. So maybe by the time you actually get a contract, we're already 3 months into the probate, right? Well, then at that point, then we'll be able to distribute funds quicker, okay? So if we're already 60 days into our probate, right, that money is only going to have to sit in my estate depository account, or the estate depository account, for 30 days, because we're at a 90-day window here. Now we have to I add in what I call my buffer months. So we have the 3-month creditor period, which is like our sitting period, but we have the 30 days before and the 30 days prior. So I always like to say I need 30 days to open this estate. Now, I don't need 30 days to prepare documents. I need a week to prepare documents. I need and to prepare and file documents. And that's going to bring me on to the next topic of our conversation, and that's what is driving these timelines, okay? So you approach your probate attorney. Your probate attorney is going to prepare documents for the estate. Those documents are then going to be sent out to the required signers, which would be your beneficiaries, your potential personal representative, to go ahead and sign off on. So they're gonna sign all the documents that I need from them to present to the court so they can actually open up my estate. So the second that I get those documents back from them is when I say those 30 days start ticking, because we want to give 30 days for the court to actually sign those documents. Now, right now, believe it or not, with COVID, everything's virtual, and they have gotten this down to a science. So if I kind of file something in Miami-Dade today, I'll have it within a week. I'll have it back within a week. These judges are just cranking. They're doing amazing. Now, pre-COVID, the only way to get your documents signed quickly was to go to the ex parte hearing. So that can be anywhere from 3 weeks out from when I actually do my filing. And that's where I take that 1 month, that 30 day, that's where my 30-day timeline comes. So a reasonable expectation would be a month on the front end, 3 months for the creditor period, and then a month on the back end to actually then go back to the court again to ask them to distribute the estate. So we go with 5 months in terms of what we think this turnaround process would be. And then you could also add another month there just to say that maybe, the beneficiaries, and it depends on how many beneficiaries they are, how long they're going to take to get documents signed and sent back, right? Or get us the information that we need. Now, what I want to do is set everybody up for success, that we can really get it to the 5 months. or less. Okay. I like to get it at 5 months or less, just a strict month on the front end, strict month on the back end, the 3 months that we can't do anything about. And what does that mean? It means that we get all the information that we need from our client right off the bat, right? So this is, and I'm going to follow up with everybody, by the way. I'm going to follow up with everyone, by the way, after this is done. What I wanted to do was kind of, before I prepared something, and I have something to send out to everybody that I'm going to have sent out with the link to this recording. So you can kind of really see everything that I'm speaking to you about today in writing. I wanted this to be a little bit more conversational here now. We have a small group, and I didn't think I needed to, like, have some PowerPoint or anything, but I do have an actual formal PowerPoint type presentation that will go out to you. And I'm going to actually add into that the questions that you guys have, and if you guys bring to light anything else that I could add to it. But in that, I give you a list of what you're going to ask your client for. And that list is a death certificate. We need a death certificate right off the bat. We need that. We need them to fill out an affidavit of heirs. So we don't need them to necessarily sign it and have it notarized, but we need them to fill it out, because that's going to let me know as the attorney who the players are. Okay. We also need to know if they have a will or not. If there is a will, we need a copy of that will. And we need to know and confirm that they have an original of that will. If they do or they don't. These are important things for your probate attorney to know. So if you call me and you say, hey, Erica, I have a client, it's definitely a probate, these are going to be what I ask you. Hey, can you send me a copy of the death certificate? Do you know if there's a will? Who are my players involved, right? So at that point, if you already have that information ready to go, like you've already had them fill out this affidavit of heirs, you can tell me all those answers, and then you send me over the death certificate. I could start preparing documents right then and there and pretty much get that timeline going, right? Like, because you want me from when you speak to me, you want me to be able to, within a week of you speaking to me, have everything that I need to go ahead and get those documents prepared. So if we can set ourselves up for success, getting a death certificate, knowing whether or not we have a will, whether or not we have an original of that will, and if we know who our players are, meaning we have an affidavit of heirs that's filled out, just filled out, doesn't need to be signed. And I'll give everybody a copy of that, a link to that as well, so you guys can kind of just have it for your reference. Then you're going to be set up for success. And you're going to actually start to be able to kind of understand and figure out who the players are. So if you have a will and you have an original of that will, and you can see right there listed in the will who the beneficiaries are, those are the people then we're going to follow up and say, I need contact information for them, right? I need their name, their phone number, their address, their email address. We need to notice these people. I need consents from these people. So in some matters, they're easier than others, right? We only have like 1 or 2 beneficiaries. I can tell you I have as much as 20 beneficiaries in certain situations, okay? And it gets rough, right? And then another thing that's important to know is, who are these beneficiaries? Are they adults? Are they minors? So that's an important thing for you to inquire. Once we find out who the players are, it's kind of like 2 layers. We get the initial information from them. We keep it simple, right? We want to get our client. We want to recommend. We don't want to overwhelm them and make them feel like they need to give you all this information in order to just, sign you up as a listing agent and get the property on the market. Because then people start to get like, all right, let me wait. I need to get this together. We want to make this easy for our clients, right? Those are simple, easy things to ask for. Fill out this affidavit of heirs for me. You don't need to sign it. You don't need to notarize it. Just fill it out. Just figure out who the players are, right? And in that, it does request their contact information. Then you can even say, we don't even need the contact information. I just need the names. Just give me the names of all the people involved, whether they're an adult or a child. That's all I want to know. Over 18 or under 18. And then we're going to get a death certificate from them, which typically they should have. And if they don't have a death certificate, I can order death certificates very easily. So in a lot of cases, they'll always have a death certificate if they've died recently. But maybe if we're dealing with an estate or property of somebody that's died years and years ago, they don't have that information. I can easily get that. So don't worry. You can just then at that point, I have a form that I can have them fill out and sign, so we can request that death certificate and get it Pretty much like within a week, if it's Florida, I can get that death certificate. Okay. So we're going to get that death certificate from them. We're going to say, yeah, do you have a copy of the death certificate? Do you know if they had a will? Yes, they had a will. Great. Do you have an original? Do you have the original? Yes, I have the original. Great. Can you just send me over a copy of it though? I don't need the original now. Just send me over a copy. So what we'll be able to do is then review what they've provided us. We're going to review the death certificate that they've provided us. We're going to review the will, and we're going to review the affidavit of heirs. Now, the affidavit of heirs only comes into play because it tells me who I need to still put on notice. Even though there's a will, I still have to notice the natural heirs. So had they not had a will, who would be entitled to it? Because those people have the ability to contest the will. So we have to give them that opportunity. Now, when it comes to having a will versus not having a will, doesn't make my process any easier, any harder, one way or the other. Like I said, I still need to contact all of the people that would have been entitled to the property, whether there was a will or wasn't a will. But I do need to review that will right off the bat if they have one, because what I'm going to do is I'm going to make sure that it was executed properly. A lot of times people have wills and we end up not being able to use those wills because they weren't executed properly. Now, that's not a big deal if the natural succession, meaning an intestate statute, that means somebody dying without a will, would be the same. So if you pass away and you don't have a spouse and you just have kids and your will says everything I own goes to my kids, well, whether you had a will or not, everything you own is going to your kids in the state of Florida. Okay. So it's not really that big of an issue for me if we have an issue with the will and everything's going to the kids anyway. Where it presents a big problem is you have 3 kids, but your will says everything goes to the 1 kid, right? But it's an invalid will. Say it wasn't executed properly. It doesn't have a notarization on it, or it doesn't have the proper witnesses, or it doesn't have the oath of the witnesses. Then we need to figure out how we're going to try to work around that to get the will validated. There are ways to overcome some deficiencies with wills, and that would just be an additional, legal research on my end. Some issues are less complicated than others. And that's kind of, what we're trying to look for right off the bat. It's the same thing like why you guys want a title commitment right off the bat, why you want a lien search right off the bat, right? When you're dealing with a real estate matter. It's because you guys want to see what's going on, right? You want to know, like, is there some sort of title issue that I need to get moving on? When we get these 3 documents from everybody, it gives us the ability to know, like, are we going to have any setbacks? And that's important for you to know as the realtor, so you can manage expectations for your buyer, right? We need to make sure that we're setting closing out far enough, right? We want, maybe this one is going to take some time. We're going to have some litigation. We're going to have some issues. Then that's not going to be our 5-month turnaround time. That's going to be a little bit longer. And the main thing is, like I said, just getting all that information off the bat. And then you're going to obviously have a probate attorney that's going to be there for you and walk you through the process. The understanding of real estate is really important when you're dealing with a probate attorney, because it's understanding the fact that there's a sense of urgency. Now, probate attorneys are notorious for dragging it out the process, right? Because their clients are dead, nobody's calling them, beneficiaries all over the place, nobody really knows, it's not their money to begin with, and people are kind of like in this slow moving, lackadaisical feel, right? But when you're dealing with real property, there's a sense of urgency. There might be a mortgage on that property, right? We need to get this thing sold before it goes into foreclosure. We need to get this thing sold before, the HOA fees rack up, or those beneficiaries are paying those HOA fees, or they're paying that mortgage every single month. They're like, I don't want to come out of pocket anymore to preserve and protect this potential asset, right? And that's something that I can also manage through with you guys if you do have clients that their probate property is in an HOA or condo association. So there's significant monthly costs that come with holding that property. I have options for them. First and foremost, options. Number 2, it's giving them peace of mind in keeping the property current. This is your asset. Yes, you want to continue to get a lawn person there. You don't want it to get overgrown. Number one, you want to sell it. This is your asset. Yes, you will get paid back for it. You know, if you have 5 beneficiaries, but it's the one person that's paying everything, I'm completely able to, and that's completely a valid expense that we petition the court for a credit back to you, you know, at the time of even sometimes closing. I can get them that credit at closing, but we can certainly get it on the back end of the estate. You just provide your expenses. So what they want to do is making sure that, and this is the takeaway from this, is making sure that your clients keep record of any money that they're putting out of pocket to maintain the integrity of the property or the estate in general, estate assets in general. So like I said, I will be providing everybody with a rundown of everything that we went through today. The main documents that you need, I'll provide you guys with a copy of that affidavit of heirs. And I'm also happy to set up one-on-ones with anybody that wants to discuss estate planning, or maybe you guys will have me back to do another presentation on actual probate avoidance and how we could avoid even being in this situation in the first place. Because that's going to be a great thing for you guys if you're connecting with clients that maybe or potentially might pass away, right? And you can help them with their estate planning and get to know who their heirs and beneficiaries are. So then when it comes time for them to sell that property, they could contact you directly and it won't even be a probate matter, right? So you're avoiding the fact that you have to go through probate with this potential client later on down the line. So I think it's good for us to open up for questioning. I took quite a bit of time here.
Yeah, I was gonna thank you again for doing this. A lot of information, and I've gone through a couple of these myself with clients, and so I could kind of tell because everybody's different. One it was a wife, but he had 2 children from 2 different moms, and they were minors. So when you talk minors, and then having them sign it, and it was like chasing signatures. It was, yeah, it got done, but yeah, it was interesting. And one thing that I like about what you were saying is having somebody that's more proactive. So the person that was assigned to be the representative, she was the wife, the widow, and she was on it. I mean, she was on that attorney, and she was, you know, so it got resolved because we were able to get the house on the contract. However, I learned something from you. They were waiting to close until I don't know what it was, and it wasn't the signatures, it was something. So I'm thinking what you were saying is that they can close, it's just that you hold the money for that time, whether it's for the vendors, or whoever has to collect, the creditors, or whoever's going to be receiving the monies after the closing. Mm-hmm. So that was very interesting. So does anybody have, I have a few questions, but I'm going to let you guys, if you have any questions for Erica.
And if I look away, I'm going to actually take down some of the questions that you guys are asking. Like I said, I want to include that in my little package that'll go out to everybody. So if you see me looking away, it's only because I am just taking down your question so I can make sure that I address it.
Questions? I have. You guys don't have. I just want to make sure you guys jump in. Don't be shy.
Yeah. Hi. Hi, everybody. It's Ty. Hi, Erica. Thank you so much. It was great, very informative, and learned a lot. I actually have 2 questions. One, I need your information because I have already a client for you. It's not quite a probate. It's a little complicated, but we'll talk about it. So I will need your information. And then the second one is what something like this would cost? And is there any difference in cost between the summer administration and the formal administration?
Absolutely. So a formal administration, including the order authorizing sale, so we're petitioning for an order authorizing sale, is going to run about a $4,000 starting cost plus costs. Okay, so that would be my fee for that. And whether I could flex on that one way or the other is going to heavily depend on how many beneficiaries are involved, because my work gets a little bit bigger and a lot, and also how involved the personal representative wants to be. I can tell you they're never going to have to go to court. No matter what, I never have to bring anybody to court. The only time I've ever had a situation in that matter is if it's actually like a contested estate. But we're assuming that this is a non-contested matter. Everybody's on the same page. There's no, and it's very unusual, honestly, quite frankly, to have contested estates. So $4,000 would be a good base cost. If it's just a simple summary administration, and it's going to go more in between the 3,000, 3,500 range.
Okay.
Because how I look at it is this. I only have to go to court one time if we're doing a summary administration that I'm getting the order at the same time. So they've passed away and everything. We don't need to file a creditor period, things of that nature. Then I'm only going to court one time. So I kind of, how I, this is, kind of between us as professionals, I'll kind of explain to you why I do my fees the way that I do them. I work on a flat fee basis, and how I kind of look at it is how many times am I going to court? And then, in terms of the package and what I have to prepare, right? So I'm pretty much what I'm preparing is the same amount, whether it's a summary administration or a formal administration. We always add in that petition for order authorizing sale, which is an additional document that I would have to do. So that's kind of how I look at it. If I'm going to court more than once, then, I'm going to have to amp it up a little bit more.
Okay. And do you have the cost? You said that's your base fee, and then there's the court, I guess the court cost. No, are there set
So
fees or?
Yeah, so my fee, yes. So you can say, so let's say our range is going to be anywhere from 3,000 to 4,000, right? For the actual legal fee itself. And that's assuming no extensive issues, right? And then in terms of what they can expect for actual costs, they're going to have a filing fee and a publishing fee. The filing fee is around $300 and some odd dollars. And then the same thing with the, with the creditor with the publishing fee. So you're looking at around 600. Give or take.
Okay. And if I understood correctly,
charge a client for would be, I'm sorry to cut you off. I'm just letting you know that.
No,
Go ahead. Charge a client for would be FedEx fees. So if I had to,
exactly. Okay. And if I understand correctly, the summer administration, you do it when the client, the person has been deceased for over 2 years. That means you don't need the 3 months creditor to file, or you do?
Correct. Now, that's not a general statement. That would be the time that we would not choose to do a summary administration if we have real property in the estate and the person has not been passed away for 2 years, because that's going to tie our hands for 3 months. We can't do anything. I'm not saying in a general sense that you can't do a summary administration if the person hasn't been passed away for more than 2 years. You absolutely can, so long as the person has been, so long as the estate is valued at under 75K. But we wouldn't want to do that. So the time that we would be looking for a summary administration, or that would work for your client, would be if the client has passed away for 2 years. In this instance, when we're dealing with real property that we want to get sold, no summary, we do not want to do a summary administration. It's not that we're not allowed to. We don't want to do a summary administration unless the person has been passed away for 2 years. So that's going to be your quick rule of thumb.
So,
thank you so much.
Thanks.
And in that case, their costs are going to be less because it's going to be a $300 filing fee. They're not going to have the $300
publishing fee.
Publishing fee. Gotcha. Yeah.
So let's say that unfortunately right now, some people have passed away because of COVID or other, just normal. And one of the things that we as realtors are, always in touch with our database, the people that we know, and that comes across. Let's say that, we find out, or we see a post on Facebook that so-and-so, passed away. How do we approach that situation? And I'm asking you, I kind of think I know the answer, but how do we approach that situation so then you can pretty much find out where they're at? Like, do you need a probate attorney? Do you have an attorney handling any of that? Like, what should we be saying to be not like, oh my God, I want to get a listing. You know what I mean? Like, but coming from contribution and what should we say? Besides, I'm sorry for your loss.
Believe me, over 5 years, I've been practicing in this area. So I've kind of learned how you have different types of people, right? When you're dealing with estate planning, it's different than probate, because estate planning, you just have to have a thick stomach, and whether or not you're going to say, like, people are like, I know I'm going to die. They're very blunt about it. Like, you don't need to beat around the bush. Yeah, like, when I'm dead, this is what's going to happen. People can be very, like, cool about it, right? Probate's different because we're dealing with somebody that's actually passed away. It's not the thought of passing away. Now, the thought of passing away can be very emotional for clients as well, especially when they have young children, and just bringing that up and just thinking about that and being very emotional, right? But the skin is going to be thicker or less, right? Now, in a probate situation, it depends on when the person has passed away, right? So if they've passed away recently, we're going to have to be very sensitive to that. And you need to be coming to their aid. And that's what you guys are doing. This isn't a sell tactic. This is genuine people. All of us are people here. And I'm sure everybody's lost somebody that they've been close to. So you can understand the position that they're in. And then if you're the person that's kind of with the task of cleaning out the house and the property. So it's coming to their aid and understanding that it costs money to own real property, right? So even if they don't have a mortgage, taxes, HOA, lawn service, things of that nature. So the sense of urgency that you're sending to them there is not like to get your money, get your beneficiary money out of this. I mean, believe me, some beneficiaries, it's like some beneficiaries, they care more about the money. I'm thinking to myself, like, well, what had happened? What would you be doing if you needed this money so bad and the person had passed away, right? So some beneficiaries, but let's just talk about like your average kind-hearted person, right? You're going to help them have one less thing to do and worry about, and that's get this real property off their hands. So they need to get this off their hands, because the longer they hold it on their hands, the more money it's going to be costing the estate, and it's more time and effort. Owning a home, maintaining a home, that takes time and effort. These people might not even be local, right? So if your beneficiaries aren't local, you're here, you're local. Hey, do you want me to go over and check out the house for you? Do you want me to, so that's something. As your listing agent, another thing that you're going to know about me is that I'm going to be at that house, at least once a week to check it out, make sure that everything's okay, make sure that it's secure, things of that nature. You're going to help them fulfill their role as a personal representative. So understanding the role of the personal representative, and that's to maintain the estate assets. So how I would say that you'd want to reach out to them is to say, listen, and here's the thing, you're already going to know that they own real property, because if you see that somebody's passed away, you could look it up in the property appraiser. You could see if there's a deed, like if their name comes up in the property appraiser and there's a deed of record in their name, right? So you're going to say, I know that so-and-so owned a house and everything, and I understand that, that can be really overwhelming. I'm not sure if you guys are interested in selling the property, or if you're interested in keeping it as a family heirloom. But either way, I'm here for you, because you're going to be there for them, number one, to get that property just at the very least into their name. So when they want to sell it down the line, you're going to be the person they remember, right? So either way, it's a good way for you to interact with clients. And it's just making them understand that, I know that it can get really pricey. Hey, the tax bill's coming. I know that tax bill's coming up in November, or well, in this case, it comes due in March. So if somebody passed away now, you'd say, I know the taxes are going to be coming due in March, and I'm going to make a commitment to you. We're going to get this property sold before then. So it doesn't, so you create a sense of urgency, but the sense of urgency is to get that off their plate, not to get them their money and kind of get you your commission, right?
Right. So if they are not interested in selling, or they can't think about that right now, they still need to go through the process, because they still need to put it in their name. So that again is something that you can help them with, because it's still the same process. It's just if you don't have a listing, for example, then you wouldn't have to do the petition, right? I think it was a petition that you have to do that you have a contract. This is the one where you were saying with the comps. And real quick about the comps, is that sort of like a BPO? Are you doing a broker price opinion on that, or is it, because you said, or is it a regular comp that we would do, like a regular, like a CMA?
It's your regular comps that you guys
Okay,
would do.
okay,
Yeah,
okay.
super simple. Like all you would do is just look at, 3 properties that sold in the area. And if it's, yeah, you would just say 3 properties that sold in the area and within the past, year, and you would
And
just,
anything that looks kind of off because like what you said, it's more or less, and why is there a price difference? Then it would just explaining why. Could be the
right. And it could
condition,
be
it could
something as
be,
simple as the beneficiaries have a sense of urgency in this matter. This property was on the market for X amount of time in order for them to get that price, and or it was sold, this was sold during peak market season, this one isn't, or something of that nature that you can just address that. But but that's only if there's a large discrepancy. And we're talking like more than $50,000 discrepancy. We're not worried about, one property selling for 10,000 less than the other. We're in the ballpark. Like my rule of thumb is like, if you're within that 50K ballpark,
right,
then
okay.
And obviously the more expensive the property is, that number will flex.
The range, right. And
But
you mentioned,
let me just kind of go back to that question about whether or not, if they're not ready to sell, you're going to want to let them know that, and this is important for you. Don't walk away from this, because there's going to be another realtor then that's going to be there, right? When it comes time for them to sell, right? You want to lead them to the probate attorney, because they're not going to forget that about you. And I can tell you this, I deal with a lot of realtors or wealth advisors more so, and I do a lot of estate planning presentations, and maybe they're not ready to like start giving their retirement, a couple $100 a month, but they're willing to pay a couple $100 to me to do a little estate planning for them. So now I become their point person, right? They've been now just approached by 10 wealth advisors or retirement or financial advisors from the time they did estate planning with me to now. But now I become their point person. So I'm their point person. Now they're ready to start doing that again. And they don't even remember how they met me, right? Well, you met me through a financial advisor. You're the one that connected me. So I remind them, okay, great. Because now I become like their point. Like they don't do it. Now they're not going to move without me. That's the concept of my firm. What are you planning for? Call me and let me know. And I will, whether I can handle it for you or not, I'm going to lead you to the person that's going to help you. So you want to be the one to get them to the probate attorney, because when it comes time to sell, you want to either make sure that they're going to contact that attorney back that you hooked them up with, and that attorney is going to remember your name. Oh yeah, so-and-so is the one that got this. And guess what? They did the right thing by getting this done for you, because you want to know why? Now you can get your money right when you sell. You own this property now. And when you sell, the money is going to go straight to you. We don't need to be dealing with depositories and holding periods and everything like that. So it is great for them to go ahead and get that done as soon as possible. So then they could just get that creditor period done and over with. So when it comes time for them to sell, they can get that money right in their pocket. Another great thing and for them to know is this, and this is another way for you guys to develop relationships with lenders, because that's a great source of business for you guys. And that's saying, once you get the property in your name, you could refi that property. You can cash out on that property. You could hold on to the property because you want to hold it as like a family thing, or you're not sure what you want to do yet, but maybe you want to pull some cash out of it. Maybe you want to use that as an investment vehicle to then buy another property once you pull that cash out. So now you've made a relationship with a lender too, that you can go ahead and refer them over to once they get that property in their name.
okay, perfect. Thank you for all those ideas. Thank you so much for your time. It's totally worth it. Thank you also for offering, if anybody wants to do any type of estate planning. I know that you mentioned that as well. So if we're doing a closing and maybe this is the second property that they're buying, I mean, even if it's the first, but I'm saying, that they might be buying more property, asking them, have you thought of doing some estate planning, and protecting your properties, etc. I have a great person that could help you with that. And then offering, whether you give a certificate or something, so we can kind of give like a gift, quote unquote, and it's off, whatever. So any of that could help us as well, to introduce you and to help them out, in that they just bought that property or that they're going through that situation of a death in the family. So That's great.
Absolutely, 100%. I do what's called and that's kind of my initial, my initial meeting is always set up with somebody, whether it just be a phone call. It's called a probate avoidance strategy. So that's something that sets me apart, I think, a little bit from other estate planning attorneys out there, is that it's not a consultation. What you're getting with me is a probate avoidance strategy right off the bat. You come with a simple list of assets. You don't need values. You don't need anything of that nature. If you have real property, yes, I would like the address, because again, I have real estate, I deal in the real estate world. I'm going to pull the property. I know how to do, honestly, a pencil title search myself. I pretty much can do, and I'm trained to do and have done what your underwriters do to prepare that title commitment for you. You wouldn't believe somebody's just coming to me for estate planning, right? And then we notice that they have all these title issues in their property, right? So we call it the legal checkup, the probate avoidance strategy. So they already have estate planning done. Well, when was the last time you did it? Do you want to get a legal checkup just to make sure everything is the way that you want it to be? And that's typically when I do a probate avoidance strategy, it's $100. And it's really cool how I package it and everything for everyone to help them understand and guide them into a lot of the things that they can do that are free. That's just simply calling up your bank, adding a payable on death, things of that nature. But I kind of help them through that process, and it's kind of like well worth the $100. And then if they end up getting documents from me, I'll credit them back a portion of that towards their legal services. But what I like to do with my realtors, because you guys are the ones that honestly send me a lot of the business. Now, the more I see that you guys are are realtors that deal with probate and things of that nature, if I'm the first person that gets the person coming to me, oh, I have a probate, and then I find out there's real estate within it, then I'm going to reach out right to my real estate attorneys to refer them an actual listing, which I would love to, and I hope to do for realtors that I work with that deal with probate properties. So what I like to do for you guys is to see where I can give you guys a little bit of value. And that's, if any of you, if you tell me that you're, in the industry, then I'm going to do for you for free. I'll waive the $100 fee. The same thing with if you want to go ahead and extend that out to your clients with the certificates and everything, you're going to show them it's $100 value, but that $100 value I'm giving to you. So that's like you giving your client $100 gift. Okay. Like that's not me waiving it for them. I'm doing that for you guys. So the certificate and everything that I would give you that you can like pair with the bottle of wine or whatever it is that you give your clients is going to be the gift of estate planning. And that's going to be $100 value. And I make it very clear on the certificate that it's $100 that you're getting. And that's my gift more to you guys. So you can, kind of step it up there, and it's not a ploy or anything like that. It's $100 thing. And you just happen to, I owe you guys, for as good as you guys could always be to me in the industry and everything.
So again, thank you, Erica. We are 2 minutes past our 2 o'clock. So you did great. No, it's amazing. A lot of information. I took 2.5 pages of notes. And as soon as I have this recording, I'll also send it to you. That way we know, you have it, you can use it or whatever. And then just go ahead and you could send it. I don't know, however you want to do it. With how you want to send the information that you wanted to pass on to the agents. And I truly appreciate you. And yeah, we'd love to have you back again, maybe in a month or so, 2 months, about whatever else you want to talk about, estate planning, or I think you mentioned what the other thing was. But I truly appreciate your time and the information. This was great. And hopefully, it's a sad situation, but if we can help somebody out and connect them to someone that is knowledgeable and that just seem, that's gonna just make it.
I think everyone should have my contact information right off the bat from the flyer that was sent out.
Yeah.
So you can get my contact information right there. But I'll make sure that everybody gets that as well.
Perfect.
Anybody that wants to follow up with me directly, or if you want, I could actually put it into the chat right here, right now, so you guys can grab it before you go.
You can. And guys, I also added that to the email that I sent reminding you guys today about that. So it has a flyer with your information. And I think I also posted that in the WhatsApp. If you guys need anything from me, it's just, I'm a phone call away, send me a text. This coming week, we have Ignite starting, and on Thursday is that business planning clinic. So please make sure that you have your budgets done, your sources, your lead sources, and what is it that you want to do for 2021. Let's see what 2021 brings. and just thank you again, Erica, for your time. She put that information there, so you can go ahead and copy and paste it somewhere else. That's what I do with all the notes that I see on Zoom. Copy and paste, copy and paste. You guys are amazing. Have a wonderful weekend, and stay safe out there. And there's opportunities everywhere. Bye.